Hello guys, Joel Torison here from Brand upstART, and today I'm talking about intellectual property rights and how they apply to you, a graphic designer. So first off, I'm not a legal expert. I'm not a lawyer. This is not lawyer advice. This is just generally how it works. If you need to take action and actually go after someone who's copied your ideas or something, consult a lawyer. So intellectual property refers to a visual communication you create that is original. This includes logos, photos, videos you take, copywriting, advertisements, websites, graphic elements, illustrations, anything like that. If you create it, if it's original, you have rights to use it and sell it. So when do the rights take effect? Immediately. For every original artistic creation you make, copyrights are automatically applied and it's free. You don't have to register anything to get this protection. Every original idea is protected with copyrights. So the next level of intellectual property protection is registered trademarks. Now this will cost you a couple $100 if you're applying yourself to take that step. So you can apply for these trademarks yourself and then only pay the application fee, but it can be a tricky area if you've never done it before and have never dealt with it. You can hire people to do it. That's my recommendation. Get a professional on your side to make sure you're paying and doing the applications correctly, because I know in Australia they tell you it's a long wait before you even get looked at, up to 6 months. So be sure you're filling out everything correctly and putting it under the right category before you file and pay and wait. So a registered graphic makes it easier to defend in court should you have to take anyone for infringing on your property. All right, so have you already been ripped off? One of your designs stolen, used somewhere else? Now what do? Well, unfortunately, you can't just call up the police and say, hey, arrest that guy, he stole my design. It doesn't work like that. It all depends on what you, the copyright holder, wants to do. So to get someone to stop using your work, or if they're going to use your work without your permission, without paying for it, without getting the rights from you, first of all, tell them. That's your first free option. Tell them it's yours, you can't do this, it's illegal. Start with that step. If they're not complying to that, the next one's going to be a lawyer, and that one's going to cost you. So to put it simply, you have to evaluate the situation depending on what it is they took and how much money it's worth to you. If it's only a simple, business card design or something like that, is it worth that much effort to go after them? So me personally, yeah, I've had a couple designs stolen that I've known about, that I've seen. And in the end, for my situation, it wasn't worth it to go after them to get reimbursed for loss or copyright protection, or to get them to stop using it. The little jobs it was fine. I didn't press any charges. I just carried on with the next client. So before you get yourself in the situation where you have to go after someone, protect yourself now. So the first one, email disclaimer. Get something in every email you send in the footer that explains this is copyrighted material, only intended for the recipient in the address bar. Do not copy, do not reproduce, all that stuff in your email so that it's covering you a little bit. Copyrights on your proofs. So on your artwork proofs you're sending to people, be sure it's on there. Copyright. This artwork belongs to your name or business name. Get it on there so on every piece of artwork they see, it's there. When you are sending proofs, try to send JPEGs raster images, not vector. Vector images are easy to steal, even if it's a flattened PDF. Anyone can go in there and take whatever they want. Even if the font's not there, they could copy it almost exactly. Send a JPEG, way harder to copy. And then, if you're not using a contract, start. So again, this is per job, per individual, as a freelancer. If it's a small job, I don't send contracts. If they're big, I do something, just something. You don't have to pay a lawyer for this. There's lots of resources online. Just write out in plain English that you own everything until you're paid or something like that. So to sum this up, yes, you get copyrights, which are free and immediately applied to all of your work. That's original. And then there's registered trademarks, which are paid to the country where you live, and that locks it in so that no one can copy your stuff and is much easier to defend in court if you have to go that way. And one other thing, as a designer, we spend a lot of time on the web. Are you copying someone else's intellectual property? I'd say we've all done it. I've done it. You go online, you find a cool graphic or an image, and you put it in something, and lo and behold, it sticks with the whole project. The client never changed it. It worked for what you needed it for, and it stays in. Don't be stealing things from Google Images or anything like that. Buy your graphics from Shutterstock or something. Make sure you have legal rights to use what you put in all your designs. All right, that's it from me. I hope this was helpful, and we'll see you in the next one.